Welcome to Day 5 of the trial version of Short Sale Your Home and Get Paid course. Today we're going to talk about the best way to file an answer if you live in a judicial foreclosure state. I talked about filing an answer in the delay strategies yesterday, and I wanted to go into more detail because this is a practical thing you can do that may very well give you 30 to 90 days. Please remember that I am not an attorney and pretty much have to advise you to run everything you do by an attorney. I do give you a sample answer, which you will see in a link below this video, but it would be well worth your time to have an attorney draw you up an answer. When you answer, you can either do it with a bunch of legalese and actually answer every point on your summons, point by point, or you can kind of put it more like in a letter form and just talk about your hardship, explain everything that's happened, what you're doing to correct the situation, and of course ask for more time. You could also kind of do a hybrid where you answer the points in the summons and then explain a little bit of your situation and ask for more time. Telling a story can paint you as a poor, unsophisticated person who has been taken advantage of by a big mean bank, and it can kind of potentially you'd be hoping to pull the empathy strings of the judge or magistrate that would be reading that answer. A more formal style, however, might get more precise results. In the foreclosure packet, there will be numbered sections, which I just alluded to. They set the facts as the plaintiff sees them and then asks for a judgment based on those facts by the judge or magistrate. In a formal answer, you would typically address each numbered section as a single fact and answer whether you either, one, agree, two, disagree with that fact, and then based on your answers for each numbered section, you would then state what you want at the end of the formal answer and ask the judge for that. I put in the sample answer, you can download in the link below, like the numbered answers that I put in. I made a little phrase, deny for lack of knowledge. You can say that you deny any fact for lack of knowledge, even if you have the slightest doubt of the smallest part of that section. So even if you're not totally sure about something, you can deny that. The plaintiff will then be forced to come back before the court with actual documentation proving their assertions. And that can take time, and it keeps the lender's attorney from just using the automated assembly line approach to foreclosing. So if you agree with all the facts and agree with what the plaintiff is asking for, or you just simply don't answer at all, it will go to default judgment, which typically the process through default judgment to foreclosure in at least the Cleveland area is 5 to 7 months from start to finish. Other places, it'll vary, but a default judgment simply means that it is a judgment by default for the plaintiff because nothing is needed to be proved or argued because you didn't argue anything. After you answer each number section, you would ask for something that benefits you based on your answer. In the example answer I include here, I state, quote, wherefore defendant asks that the plaintiff's complaint be dismissed. So I ask that the plaintiff's complaint be dismissed on that one. But you could also possibly say something like, defendant wants to avoid another foreclosure in Cuyahoga County, is attempting to sell property and has listed it with the local licensed real estate agent. Wherefore defendant asks that plaintiff's complaint be delayed for 90 days while defendant attempts to sell property and pay plaintiff amount due. After you've completed your answer, you would simply file with your county clerk of court's office. Filing would be completely free for you. You may want to check with your clerk of court's office to see if they have any extra tidbits or advice for you. Usually you can file your answer by simply mailing it to the clerk of court's office, but call and ask first. Otherwise, you have to go to the clerk of court's office and file it. Also make sure that you insert your name and plaintiff's attorney's name, and don't leave any of the form things that I left in there. Change it to your situation. The proper case number, make sure you're referencing the proper court, and make sure you mail a copy of it to the plaintiff's attorney as well. In addition to this sample answer, I also have a sample continuance. You would file it when the date of the first hearing is set. This could easily buy you an extra 30 days as well. As always, please give me your questions and comments below. I'll attempt to answer them as best as possible. and I'll see you tomorrow.
If you came to this video by a friend forwarding it to you, or you stumbled upon it on YouTube, make sure that you opt in. Go to estopforeclosure.com and opt in to receive all of my 7+ foreclosure short sale training courses and counting. I have all sorts of goodies in here, as well as special offers on my short sale course. I have a 30-day quick start if you're approaching foreclosure quickly. I have more than 16 different ways to delay foreclosure. I have over 18 options for you in foreclosure if you're just not sure at all what to do. And I'm going to continue to add new content. So this is a good opportunity for you. There's an opt-in on the front page of estopforeclosure.com, and I look forward to seeing you there.